Good evening and welcome to the Society of Labour Lawyers Fringe meeting on the future of the justice system. We're coming to you during Connected, the Labour Party's online conference this year. And this is in conjunction with the Law Society and the Bar Council. I'm Kate O'Rourke, I'm chair of the Society of Labour Lawyers and I'm chair of the meeting this evening. Continuing in a long tradition of Sunday evenings at Labour Party conference, I'm delighted that you all can join us this evening. But unfortunately tonight you have to supply your own warm white wine and your own crisps, which we can't do for you this evening. Our panelists tonight are leading representatives of the law in the United Kingdom, and I know that they will come and be informed, informative, and I suspect at times slightly challenging. In order of appearance, we will have the Right Honourable David Lammy MP, Shadow Lord Chancellor and Secretary of State for Justice, Ellie Reeves MP, Shadow Solicitor General, and formerly an administrator of the Society of Labour Lawyers. It was quite some time ago though. Lord Charlie Falconer, Shadow Attorney General, and of course a former Lord Chancellor. Pinto QC, Chair of the Bar Council, and Simon Davis, President of the Law Society. The format tonight is the familiar one of presentations from our panelists for about 10 minutes each, then it's over to the audience for questions. We have had a number of questions submitted in advance, but happy to take loads more, so please email them using the question button at the bottom of your screen, which I hope you can see. We will take as many as we can after the presentations. Now, just a couple of apologies from Ellie and David, who will need to leave a bit early, but if there are any questions that are specifically for them, we will forward them on afterwards. Now, before we start, I would just like to take the opportunity to pay tribute to one of the greatest lawyers of our time and an absolutely inspirational woman, Ruth Bader Ginsburg. Her achievements, particularly in the field of equal rights, inspired a whole generation of lawyers amongst others. And I'm sure that all of us tonight will share what I'm sure is her absolute frustration that she died at a time when there is still the possibility that Trump and the Republicans could potentially appoint a conservative to replace her and thereby shift the balance of the US Supreme Court to the right for some time to come. Now, of course, our own Supreme Court is in danger of being undermined as well. And I suspect that might be addressed by some of the presentations or some of the questions this evening. So without any further ado, I'd like to hand over to David, our first speaker. Thank you.
Well, can I thank you very much, Kate? Can I thank my colleagues, Charlie Falconer and Ellie Reeves, great friends. And can I say that Amanda and Simon are on sort of speed dial at the moment for the official opposition. So this is a very, very cozy meeting, I might put it that way. The Society of Labour Lawyers for the support that you give the Labour movement and the way that you support us as a front bench team, being able to lean in to expertise and being able to understand what's going on the front line on a day-to-day, week-to-week basis. We are meeting in an extraordinary way. I would much prefer us to be together physically and at an extraordinary time. And I have to say, as Shadow Justice Secretary, but also as the MP for Tottenham, I'm sort of thinking not just of where we are now, but the year ahead. I'm thinking about the huge job losses that are to follow. I'm thinking about the hardship amongst poorer people, working people, right up and down the country. And in a sense, it's that context that I recall in the 1980s that drove me into law and politics in the first place. I'm thinking of those who advise so many on welfare, families that will be under strain, and the importance of our family lawyers, employment lawyers doing all they can at this time when big companies like BA and others are effectively playing with the law. And of course, at this time, the pressure that we find in our criminal justice system, particularly housing, so many areas of public life where we need our lawyers and we absolutely need access to justice. Now, the truth was, before the coronavirus, before where we are today, our criminal justice system and our wider justice system was creaking. If you look across government departments, the MOJ share of funding fell year on year. The backlog that we have in our criminal courts was amassed long before the coronavirus. The overcrowding, the underfunding, the real problems in our prison system happened long before coronavirus. The huge, vast deserts where you couldn't find legal aid happened long before coronavirus. And frankly, there were junior lawyers at the criminal bar and amongst our family of solicitors, particularly those dependent on legal aid, that were long before this thinking of packing it in. But where we are today has accelerated those problems in a way that I think none of us this evening could have foreseen. And I am very, very concerned about the future, frankly, of those who both need legal aid and those lawyers who have continued to work within legal aid at this time. And I have to tell you, whilst, of course, I welcome the fact that the government have finally got on with CLAR 2, I'm pretty sceptical about where it will end. We've seen a lot of promises over the years and very, very little return. We finally got the government to realise that they needed to do a U-turn on the probation system. And we will keep very closely a watching eye on what results from that. But I can tell you at this point in time that reoffending rates in our country are the worst that they've ever been, and certainly the worst in Europe. What a figure, what a statistic, that rehabilitation isn't actually working. So we have a court system in crisis. We were arguing and saying at the beginning of this crisis that there were civic buildings right across the country that were sitting empty and are still sitting empty. There are some universities that are not likely to return. There are town halls that are sitting not open. And yet the government has been so slow to bring forward the Nightingale courts. It's unbelievable. But the other concern for anyone who believes in law and that fundamental principle, not just of justice, but of consistency and proportionality, is the worrying way in which we're seeing executives across the world lean into an awful populism, a far-right populism, to dismantle democratic norms. So this government was quick to say, well, actually, maybe we don't need juries. The government has now had to extend custody limits. Innocent people will be sitting longer in prison, and we don't actually know the numbers of those affected following an FOI just last week. We don't know the numbers. And of course, the shameful behaviour of our Secretary of State for Justice in seeing the rule of law broken, but not willing to stand up for his oath. Let me be absolutely clear. If this had happened while I had been the Secretary of State for Justice, I would have resigned, because the oath I took and my commitment to social justice and justice means that, of course, if the rule of law is threatened in this way, you should stand to one side. Our current Secretary of State is a small and diminished figure as a result of where he is. And the attack on judicial review. Where is the evidence? Where is the evidence that you should go after judicial review in this way? It feels deeply political. And I remind this community that whilst you might look at the panel, the folks panel, and you've heard what folks have said about Brexit in the past, and see some figures there who are balanced in their view. Remember that this group will report to Michael Gove, principally, and Robert Buckland just behind him. And then they will come forward to Parliament. And I'm afraid they have a majority of 78, as we saw this week. So this is very serious, this attack on any challenge to the executive. It's a government where there is one rule for Boris Johnson and Dominic Cummings and another rule for everybody else. Even those who've lost their loved ones as a result of COVID-19, not able to force the inquiry that they should have or challenge in the way that they should, those people would be denied this because of these changes to judicial review. And they're coming for more. They're coming for human rights, fundamental principles that even their former leader Churchill stood up for. They're coming for the Supreme Court. All of this out of the Donald Trump playbook. So my own view is that these are extraordinary times for myself, for Charlie, for Ellie to be in this role as the official opposition, to face an uphill task. Of course, we've got a leader in Keir Starmer that understands these issues intimately, but to face an uphill task because of the massive majority that they have, but frankly, because there's a recklessness in number 10 about issues that we all cherish, and that in governments of the past of whatever colour, frankly, there has been consensus. As we head into the autumn, I'm sceptical that the numbers that they're suggesting of court cases coming back will come back in the way that they are. I'm worried that we will see, as we head into 2021, law firms and barristers' chambers going to the wall. I'm worried about what access to justice will look like by the end of 2021, given it's pretty dire at the moment. And I'm deeply worried as we head into this spending review and further austerity, where that will leave the justice system. Don't be fooled by money for court infrastructure. Believe me, this is a government that will give with one hand and take with another. So extraordinary to meet on a Sunday evening. Very interested to hear what you've got to say. Of course, I could have said a lot more, but I don't want to, dominate the whole time about what a Labour government would hope to do when we are in power. Obviously, I want to see the review that I led, a cross-party review, implemented in full and to go further, remembering that when I did that review for David Cameron, 41% of young offenders came from a Black, Asian and minority background. Today, the figure's 51%. Staggering, frankly. And to say that I remain committed to seeing the amount of women in our prisons reduced. Never met a woman in the prison who isn't there, frankly, as a consequence of a man who's abused or pimped her. We need to reform further our justice, our youth justice system, not reformed since the early years of Tony Blair, and with some of the challenges with young people with knife crime and gang crime, real issues there, of course, that we need to address. And of course, we want to do more than the government's prepared to do on those who reoffend and dealing with rehabilitation. But I'll end there. Very, very pleased to join you.
Thank you, David. I just wondered whether you wanted to say a few words about the research project that you're working on at the moment, because I know that it goes to the heart of some of these issues.
Well, one thing that we're all aware of, and I hope I can say this without offending anybody, is that this government frequently uses caricature to frame the very, very serious issues of justice that we all care about. And those caricatures are that legal aid lawyers are fat cat lawyers, and that all of us, even Charlie Falconer, represents a metropolitan elite. And it's brutally unfair, but that's what they do. And for that reason, this is a bit more serious, you know, it's really important that when we're talking about human rights, when we're talking about legal aid, when we're talking about law and order, particularly in relation to prisons and other areas, that we're using language that ordinary folk understand, and not just guardianistas. And for that reason, I'm wanting to do a piece of work alongside my colleague Nick Thomas Simmons in the Home Affairs, that look at those particularly who voted Labour in the past, who are not voting, didn't vote Labour in the last general election, often in those red wall seats, but also in seats that we won in the past in parts of the southeast that we'd like to win again, to see what language is most appropriate when we're talking about these issues. There was some work actually previously done by the Human Rights and Equality Commission on human rights language and how best to talk about human rights, but we want to extend that. And that's got to be paid for, because you know you have to get YouGov and others to do that work for you, and that focus group work. I'm very grateful actually to some members that have been able to give, and we've raised £9,000, but I'd hope to get to £15,000. And so if there are, and this is really, this is at the heart of what we need to do, and you'll understand, to win power again, and to not allow the Conservatives to frame what we're saying about judicial review as a tiny issues that should preoccupy only those who live in Islington in North London. So I hope that members will be able to support this, and I'm very, very grateful, Kate, for your sort of help in getting this message out. And if you could sort of make contact with the Society afterwards with any donations, I'd be very, very grateful.
Thank you. I'm going to head over to Ellie now.
Thanks very much, Kate. And it's really fantastic to be speaking with the Society of Labour Lawyers this evening. I think getting on for 20 years ago now, when I was the administrator of the Society, I was partly responsible for organising the Sunday night conference Fringe, and it's a real shame that we can't meet in person, but great that we're able to at least have this meeting via Zoom. For my part, I was delighted to be appointed Shadow Solicitor General in April of this year. I was an employment rights lawyer for many years before entering Parliament, and after being elected in 2017, I served on the Justice Select Committee for several years. So I was really, really, really pleased to be able to take up the role. And I think there are many, many challenges ahead. David's outlined a lot of them, and I know that Charlie is going to be talking about this government's complete disregard for the rule of law. I do want to say something about that. I'm going to talk a bit more in detail around the CPS and prosecutions, particularly in domestic violence and rape and serious sexual offences, because I think there's a huge amount of work that needs to be done there. But I don't want to not say anything about what's happening with the rule of law at the moment. This is a government that has complete disregard for the rule of law, which has been shown by the fact that the Attorney General seems completely comfortable with the government breaching an international treaty. You know, they've made clear you had Brandon Lewis saying, well, we are going to break international law, but in a limited and specific way. I mean, what on earth does that mean? It means that they're going to break international law. And then you've got Buckland saying that he'd resign if there was a breach of the rule of law in the way that was unacceptable to him. Again, it's just absolute nonsense. They're determined to trash the rule of law at every opportunity, and I think that we have a role, David, Charlie and I, to really hold the government's feet to the fire on this and not let them get away with it. You know, we know what's coming next. We know there's going to be attacks on the judiciary, judicial review. There'll be attacks on Human Rights Act. And this is very much part of their agenda. So certainly in my role, it's something that I really want to be holding them to account on. But I just want to talk a little bit about domestic violence and serious sexual offences, because we've seen a huge surge in domestic abuse cases during COVID. In the first month after lockdown began, 16 women and girls were killed in suspected homicides, more than triple the number from the same period in 2019. But the problem that we're facing is that the CPS and the judiciary are just not equipped to deal with the surge of cases that's coming. Even before the COVID-19 crisis, government cuts to the CPS and legal aid have left many, many victims of domestic violence without access to the justice they deserve. Over the summer, some work that I was involved in was looking at the fact that people are left to represent themselves in domestic violence cases. In 92% of domestic violence cases in the family courts in 2019, one or more parties was left without any legal representation. So for those cases that did manage to get through the backlog and get into a court, in 92% people were left to fend for themselves, which, you know, if you're a victim having to face your perpetrator in court without representations, it can be absolutely devastating. It has a clear effect on access to justice. At the same time, we've seen that the domestic abuse caseload in the CPS and the police has increased by 88%, whilst there's been a 25% reduction in funding for CPS and the police dealing with those cases. So I don't have a lot of confidence that CPS has the resources to deal with domestic abuse cases, even at pre-COVID levels. Coupled with the rising cases that we've seen during the pandemic, we're left in a situation where the resource just isn't there at all. I've raised this with the Attorney General at Attorney General questions, and the response, quite frankly, has been lacklustre. I think I've raised it in the first Attorney General questions that I did after being appointed as Shadow Solicitor General, and we were told, oh, well, there's funding for a helpline for domestic abuse that's been set up, so we really care about this, and we're doing a lot of stuff around it. But the reality is that money isn't going into the CPS to prosecute these cases. It isn't being properly resourced, and unless the government gets to grips with this and properly fund the CPS to tackle these cases, there are going to be lots of victims who are seriously let down. Sadly, there's a similarly bleak situation when we look at rape and serious sexual offences. Huge delays in jury trials caused by the pandemic. Latest statistics from the CPS showed that fewer people were being prosecuted and convicted for rape than at any other time since records begun. Now, this isn't just caused by the pandemic. I think the backlog of cases across the piece was 47,000 pre-COVID, and the reality is that the government have had a huge amount of time to get this sorted. We have been calling on them to open Nightingale courts from day one, and yet the government was extremely slow to act, extremely slow to get jury trials back up and running again. As David said, you know, there are there are lecture theatres, there are sports halls sitting empty, and the government could have commandeered these to get trials up and running again, but they weren't interested. So a huge amount of backlog, coupled with these really, really quite worrying figures about rape prosecutions being at the lowest level since records began. And there's some serious questions to be asked about why that's the case, why the CPS aren't prosecuting these cases, because it's deeply worrying. Now, what they might say is, well, the prosecutions just aren't coming through from the police. We know that wasn't, at least initially, true, that the police were sending cases, but the CPS weren't then charging on those cases. And it looks like what's happened over time is that the police are thinking, well, we keep sending these cases and they're not, and we're not getting people charged on them. So, what's the point of sending these cases in the first place? And it's become a bit of a vicious cycle. So you can't explain away the numbers by saying, oh, well, it's the police's fault, they're not sending through the cases. The CPS are looking at it. They have published a 5-year plan for rape and serious sexual assault. But it's really concerning. It's taken this to get to this point with so few prosecutions now for rape. I think in 2019 there were 55,000 reported rapes in England and Wales, but only just over 2,000 prosecutions and 1,400 convictions. So seriously low levels, and it's taken this point to have this review in the CPS. I think action really needed to have been taken sooner to get to grips with this. I think there's a question not only of resource. We know the CPS is underfunded. There's a big issue around resource, but also how the CPS are looking at these cases and what is influencing their charging decisions. And it's something that, as Shadow Solicitor General, I want to really, really be pushing on. It's an incredibly serious issue. And, this 5-year plan, well, victims of rape and serious sexual offences haven't got 5 years. They can't wait 5 years for their justice. Already people are being told, oh, your cases aren't going to be heard for a long time. We know convictions are low. The worry is people just will stop reporting the crimes in the first place, or just fall out of the criminal justice system because they feel as though they haven't got a voice. So to sum up, I think a lot more needs to be done to ensure that victims have confidence to come forward, and that the CPS is properly equipped and resourced to deal with their cases, and that the courts have capacity so that cases are not taking years and years to get heard. These are issues that I'll carry on pushing the government on. It is an area where we do need very swift and urgent action, and I think that from our perspective, from Labour's perspective, it's something that we'll be pushing on very hard. Thank you.
Thanks, Ellie. And the Society is setting up a working group to look at some of these issues under the leadership of Diba Saeed. I'm sure you know Diba. She's the Senior Legal Officer at Rights for Women. So we'll certainly be in touch with you, because it's an area of concern to a lot of our members. So thank you for that.
That would be fantastic. Thank you.
Great. Now, Charlie, you've been on a number of these panels in the past, and it's delightful to see you here again.
Kate, it's really great to be here. It's terrible that we can't meet in person, because these are important events for all of us. And it's also terrible that we can't meet in person when I think the fundamentals are in play for the first time in my political lifetime. Could I say a special thank you to you, Kate, to Joe Vincent, the administrator, and to Stephen Hockman for the huge support that you've given the whole of the Labour front bench over the last 6 months and beyond before, in providing us with access to legal advice. And each one of us has felt, and it's not just the 3 ministers or shadow ministers, sadly, on the call today, it's the whole front bench feels we've got access to first-class legal advice, better than the government is getting, and it really makes us feel good. Could I also say I have never known a stronger legal team in Labour, whether it be in government or not. Ellie has been absolutely terrific at revealing the uselessness of the current Attorney General in Parliament, which is incredibly significant. David has huge authority on legal issues, and I think David, of all individuals, was the person who stopped the government in its tracks from introducing restrictions on jury trial rights, because in David's report that he had written, he said the one area that was functioning in a way that was not perceived to be racist was the jury system, and that was the bit that the government reached first. He is assisted by 4 others, Carl Turner, Peter Kyle, Alex Cunningham, and Lynn Brown, and they are an incredibly strong team. We need a strong team at the moment because the fundamentals are in play in a very big way. And I had no idea of the extent to which the fundamentals were in play until the last 2.5 months. The first of the fundamentals that is in play is the law itself. And I had never thought the law itself would be in play with the government, and it is. And you've all seen what's happened in relation to the International Law Act. I would just draw attention to 2 aspects of that. First of all, there was a rebellion by Tory MPs that collapsed the moment it had started, when the government promised that before they introduced orders that in effect set to one side the law, they would have a vote in the Commons. Well, the collapse of the rebellion indicates that that's of absolutely no protection whatsoever. In the process of agreeing cravenly to support the government in relation to it, the rebels also agreed that the Lords would be knocked out of any power in relation to determining whether or not the exercise of the power was lawful, thereby getting rid of any possible hiccup there. And secondly, they've agreed to restrictions on judicial review being introduced for any assaults on the exercise of the power. That is putting to one side the fact that they would agree that nothing should be done about the very act of passing the act, which is itself a breach of international law. And my God, does it matter? It matters in a time of COVID because the law is understandably being put to one side. The government is living genuinely by decree at the moment because that's what everybody accepts has to be done. The awfulness of what has happened is that it sets a precedent. Law itself being defended depends upon the Lord Chancellor and the 2 law officers in the government. We haven't heard a word from Michael Ellis, who is the Solicitor General. I don't know if he knows about the law at all. Suella Braverman has issued an advice saying within our constitution, it's possible for Parliament to legislate to say anything, which is true. And she has said nothing about the breach of international law. And the Lord Chancellor has said exactly what Ellie has said. He said, which is if it's acceptable to him, then he'll preside, he'll allow breaches of the law. Well, they're the people we depend on. They are the people that the state depends on to protect the law. I mean, I'll be really interested to hear what Amanda and Simon have to say about their positions, not Simon and Amanda's positions, which are in every single respect wonderful, but the positions of the 3 law protectors in the state. That's the position on law. On position in relation to rights, David and Ellie were absolutely right. They're coming for your rights. Judicial review is the first to go, and then it's going to be human rights. And it's going to happen because it will look good politically. And I think they will save up the attack on human rights until the build up to the next general election. They will make the lawyers look like they are the people holding back progress. And my God, will we not the lawyers, we the population will suffer as a result of that. And then the third thing that they're doing is attacking access to justice. They have slashed legal aid. They have slashed expenditure on the CPS. They've slightly increased it a year ago in order to try and cover up what was going on. What is the point of equality legislation if you can't get a lawyer to pursue your rights? The whole point about Ruth Bader Ginsburg was that she, through the courts, promoted equality. And what this government is doing is ensuring that for the poor, for the discriminated against, there won't be the lawyers there to provide the sorts of protection that Ruth Bader Ginsburg, as an academic, as a lawyer, as an advocate, and finally as a judge, made sure that people got. David is so right when he says we've got to look at the language that we use in racism. Nobody has any sympathy for lawyers. Everybody has sympathy for a state that pushes to one side those who need help. Everybody has sympathy for those who really need help and the state ignores them. And that's what's happening now. And it's going to get worse and worse and worse. In a way, the great debates of the past in the Society of Labour Lawyers about how we would move forward in a gradual way to improve people's rights. Now, as I say, the fundamentals are under attack. What do we do? I wonder if now is the time, and this is for debate, it's not in any way policy, but I wonder if now is the time for a written constitution to provide protection. I wonder if this is now the time for Willy Bach's main recommendation, which you needed an independent body within government to determine what the minimum entitlement of people were to legal rights. I am so proud to be a member of the Society of Labour Lawyers. I'm incredibly lucky to be part of a shadow team that will fight the good fight, but we can't fight the good fight without the society, and we can't fight the good fight unless we're also supported by the Bar Council and the Law Society, because for them, as they have demonstrated, the fundamentals are now in play, and they above all have to call out the government and those in the government who are allowing this to happen. Thank you.
Thank you, Charlie. And you preempted the question I was going to ask later about whether or not, given the state of this government and the lack of leadership in the time of COVID and Brexit, whether it is time for a written constitution. So maybe it's something that we'll pick up a bit later. I want to go to Amanda now, and a couple of the questions that we've already had submitted, Amanda, do relate to barristers, and in particular, not just about the problems with the courts and delays, but also about the issues with the junior barristers and their difficulties over the past year, or 8 months, I suppose. And I know you've had a report issued on this, but I would also like to say thank you to the Bar Council for helping to sponsor tonight's event as well.
Thank you very much. Well, this time last year, I was at your meeting in Brighton, and it was a different feel, because on the train going down, we heard that the Supreme Court judgment had just come out in Miller 2, and I remember the mood of the meeting was incredibly celebratory, actually, and needless to say, everyone was very distracted. I'm going to try not to repeat what those before me have said, just because I want to concentrate on, as you say, Kate, some of the questions that have already arisen. I'd like to really deal with four things if I can. The first is the current landscape of domestic justice. The second is the young bar in particular. The third is the threat to legal practitioners by what's going on. And fourthly, really, where next? And I hope to do that within the time that I'm allotted. So it seems to me that the fundamental that we should all be looking at is access to justice. All of the other bits don't matter unless they support and give access to justice to everyone in the country, and everyone is under the law and everyone can enforce their rights. and some of the issues that have been discussed and some of the things that have happened in the last few years have definitely undermined access to justice. Our most recent survey of the bar revealed that 80% of barristers don't feel that people are able to access justice at an acceptable level during COVID-19. I think that is a truly shocking statistic. This is not about barristers talking about themselves, it's about what really matters, which is our clients. And that has come about, I believe, as a result of years of underinvestment. And now with the pandemic, the justice system is perhaps even more at risk of collapse or not being in a position to allow people to defend the rights that they have under the law. We did a report called Small Change for Justice, and it was demonstrating really that the spending on justice has gone down quite extraordinarily between 2010 and 2019. In 2019, so before COVID, it was just 39p per person per day, which is first of all far less than any other government department has, but also far less than other countries in Europe spend on justice. And it's declined in real terms in just about 30% since 2010. And as you know, this has manifested itself in a number of different ways, but one of them was the reduction of sitting days. So there were from just under just 97,500 sitting days in 2018. Last year, there were a 16% reduction in sitting days. And although just before COVID, the Lord Chancellor announced that he was going to give another 4,700, so he was going to actually bring some up, it still was an 11% reduction. So it went from a 16% reduction to 11%. So it's no surprise. I think the correct number is that there were 35,000 outstanding cases in the Crown Court before COVID struck. And there were 39,000. And in the Magistrates' Court, 407,000 outstanding cases. And as of August, just to give you an inside sort of track on the numbers, in August it was 46,500 cases in the Crown Court and 517,000 in the Magistrates' Court. So although it's right to say that in the recent past, actually, the Magistrates' Courts are getting through more court work, they're disposing of more work than they're receiving, they are obviously starting at a massive disadvantage. So that has all of itself had a huge impact on access to justice. And of course, to look at it from the point of view of the bar, whose job it is with solicitors and other legal practitioners to represent members of the public, the government has disappointingly given us no help whatsoever, despite our recommendations and despite a great deal of effort put into explaining why it was necessary, for example, to give an extension of the self-employed scheme to those young barristers who didn't have tax returns and therefore were not eligible for the self-employed scheme. And you may ask yourselves why that matters. The reason why it matters is because what we have found from, again, our surveys, is that the junior bar, 21% of the junior bar did not expect to renew their practicing certificate next year. So where are the lawyers of the future? Where are the people who are going to represent the ordinary members of the public who have a right to access to the courts, without which there's no point in having any rights at all? So for my part, that was one of the most disappointing things that happened was the lack of any kind of support for those young practitioners, not just, as it were, for themselves, but most importantly for access to justice in the future. So it's right to say that there are now more sitting days. I don't believe, in fact, there's any cap on sitting days. There has been a one-off additional capital funding, which is great because, frankly, I have sat in courts with waste paper bins on the desk, catching the drips from my judicial desk as I've sat as a recorder. And we know that there's one court building that can't be opened because the roof falls in. So those sorts of things are really important, but they are basic, if I may say so. They're needed, and we're delighted that they're being fixed, but it shouldn't really be something that we're trumpeting about. It should be that it's just part of the normal sustenance of the justice system, which, to my mind anyway, is as important as education and health, because without it, everything else is at risk. So, as you know, one of the things that has happened as a result of the pandemic is that many courts have either had to stop working temporarily, or they can work, but they're very reduced in the amount of work they can have because of social distancing. And so we have been looking, and I, on behalf of the Bar Council and the Law Society, who's been involved as well, have been part of a group across government departments and the judiciary to try and work out how we can increase the number of courtrooms and the throughput of volumes of cases right across all jurisdictions. And if I may say so, that has been a real positive. It is actually more difficult than you might think to adapt public spaces to be courtrooms, and it's particularly difficult actually for criminal cases, even if they're not custody cases. But nonetheless, what we need is greater investment in order that all jurisdictions can try more cases and reduce the backlogs, because there are backlogs, as you know, in all the jurisdictions. What we are asking for is that there are a number of strands to this. So, it seems to me that they're kind of obvious. The first, of course, is that every bit of the court estate that can be used is being used, that you have proper use and continued use of technology in the right cases to have remote hearings, so that you can have doubling up of court estate in effect, that the technology that's available is robust, it's available to members of the public so that they can really participate in their cases, because without that they haven't really got access to justice, that the court listings are done in a sympathetic and efficient way, so that those who are representing people can continue to represent them, and they're not listed at a time or in a way that they cannot be involved in the proceedings. That there are more Nightingale courts, and there are enough judges with enough supporting staff. And it seems to me that's a really key point, to have enough supporting staff to take those forward. Because if you don't have all of those bits of the jigsaw, you will not get rid of the backlog. And in respect of every single part of that, including listing, it needs resources, it needs money, and it needs it to be not just a handout here and there, but sustained. So I know, because I speak to David and Charlie very frequently, they are sceptical about the criminal legal aid review. If I put that like that, I know that they will want to use some adverbs or adjectives to make it even greater, but let's just leave it at that. For my part, if the criminal legal aid review is run by a person or a panel that understands criminal justice, and it has a commitment and drive to push it forward, and it really does intend to look at sustainability of the professions in order to enable access to justice, then that will, I think, be good for the long term. So looking forward, that seems to me to be a really important part of what we should do. And can I just say that it isn't just the young barristers who are there that are at risk. And of course, as you'll understand, they are the most diverse part of our profession. And so when we undermine them, we undermine diversity, not just now, but for the future. But we are finding that chambers are unable to support pupillage in the years to come. They've committed to the ones that they've already got. They've had to defer, in some cases, a commitment to have tenancy applications heard this year because they haven't had the opportunity to see their young pupils and in court, and there just hasn't been the wherewithal perhaps to see whether or not they're going to be tenancy material. But all that does is to push back the idea that we're going to have sustained barristers coming through if it's right that chambers don't feel that they can commit because of the reductions in the fees that people have earned to having pupillages in the future. If I could just finish with this. Moving forward, we have made submissions in relation to the spending review because it seems to us that the only way that things are going to change under this government in a real way is if there's sustained, long-standing commitment to funding the justice system from the very beginning, from the police to the very end, to probation, to the prisons and beyond. And there must be, as I say, better use of the court estate. And so for my part, all of these are absolutely crucial to enabling people to exercise their rights and really have access to justice.
Thanks, Amanda. I mean, you've really highlighted and underlined a lot of those issues about the impact of COVID coming on top of years of austerity and underfunding of the legal service. And I didn't hear much optimism in your discussion of the future, unfortunately. So maybe it's a discussion we need to have under looking forward to 2024. And, you know, I'm now thinking that maybe the Fixed Term Parliament Act wasn't such a good idea. But anyhow, so Simon, we've been on lots of panels together over the years, and I'm really delighted that you've been able to join us again tonight. So over to you.
Well, thank you very much, Kate, and like your other speakers, although I'm mostly pleased to be with you all remotely. Such a shame that I couldn't be there with you and with you all physically like I was last year. So first, also some thank you to David, Charlie, and of course, Carl Turner for your constant support for the profession. And as already been said, the profession does not exist in a vacuum. It's there to serve the public. So thank you for that. And thank you also for the very detailed report which Carl Turner and his team put together in relation to coronavirus and the criminal justice system, which made absolutely clear that in many respects, without the funding which is required, it is, and I quote pretty much the report, on the verge of collapse. But I want to do something slightly different because otherwise I'm just going to really end my little talk by saying ditto and approach it in a more holistic way. As I'm often asked, I'm sure you all asked, what are the kind of qualities that a good lawyer needs? And you find yourself saying the ability to listen, to put yourself in the shoes of the client, to communicate simply and effectively, to provide solutions, not problems, and to be innovative. And certainly in my many hundreds of years as a civil litigation solicitor and then latterly in the Law Society, I often find that the qualities that we expect of lawyers are not to be found within the system of justice itself. And that is what needs to change. And I think that the effect of the coronavirus in certain respects will give that change the necessary kickstart. So let's just look at listening. The system of justice depends on us listening to the people who need the system of justice most, the public. And when you speak to the public, it's pretty obvious what they want from the system. They want their voices to be heard. They want their problems to be addressed fairly and as quickly as possible. And then if things can't be sorted out, for some kind of resolution. And this shouldn't be difficult. So what's the obvious starting point? You have a problem with somebody or a business or an employer, and you need help. The first and obvious point is you should be able to go to a lawyer, solicitor, or a barrister, a legal professional who's able to say to you, look, here's the actual problem you have, maybe not the one they thought they had. And here are some practical suggestions as to the way forward, all with a view to being resolved without you necessarily having to come into the system of justice in the first place. And there has been so much work which has been done around the world, which shows that that early investment in relation to early legal advice reaps great dividends, not just in terms of cash, but the reduction in human misery down the track. And that is why we have consistently called for investment at that early stage in early legal advice with a view to avoiding the system being clogged up even more than it presently is. In relation to the next stage of what the public clearly wants, they want therefore to be able to go to get some early legal advice. And as we've already heard, in many respects, people just find they're not even eligible for it. Domestic abuse already being touched on. There you find that the person being abused regularly, obviously the wife, can find that they're not eligible for legal aid simply because they have an equity share in the house, and this must change. Then, having been able to go to see a lawyer, you'd quite like there to be a lawyer there when you get there. And the present position is so serious that we find in the context of criminal that only 1 or 2% of trainee contracts are in crime. We find that the average age of criminal duty solicitors is now approaching 50. If you go anywhere, as I have done in the last 3 years, and speak to people, would you advise somebody you know coming out of university to go into the criminal law? And the answer is always, oh, absolutely not. So either they don't come in, or they do come and they leave. Now we have the irony that some of them maybe go to the CPS, because the CPS, of course, lots of solicitors, I'm not in any sense denigrating them, but the CPS, as the prosecution, had a substantial, nearly £80 million of investment. But where is that on the defence side? In the context of the virus, we have been asking for what I would say is a very underwhelming degree of support from the government in relation to them reorganising and not clawing back the system of monthly payments, but to no ado. So the first step which needs to change, we need early legal advice, and we need lawyers there to give it. The next, where I would like to see a change, is in the approach to legal health. And I would like to see that change more to the kind of approach you see in the national health system, which is one which focuses on prevention rather than on further examining what's happening at the resolution stage. So what do I mean by that? I mean by that it is actually not difficult, let's focus on the civil side, to understand what are the most common problems which people have. And their debt, their social welfare, their immigration, their housing, employment, and family. And in crime, again, we can see that many of those who are coming into the system struggling with a combination often of illiteracy, mental health, drug abuse, and some extremely unhappy family upbringings. What I would certainly like to see, and the law side would like to see, is real focus on what is it that leads to people coming into the system of justice in the first place, and try to stop it there. Litigants in person being a very good example, Kate, as you will know, the numbers continue to rise of these poor people who've got no legal representation at all appearing in the courts, bewildered, struggling, and the system is, as a result, even more overburdened than it should be. What I'd like to see is not just obviously the kind of financial support which has come in to help litigants in person when they come in, but a very careful data-driven exercise which tries to understand why these people are litigants in person, what areas of the law that are they coming from, and what efforts can be put in to stop them coming into the system in the first place. And it's one of the reasons why you know that legal clinics around the country have been so overburdened and are struggling right now, and having had some kind of now cash injection from the government, which recognises their huge importance. Then, if we turn to communication, I'll just deal with that very briefly, but I think it will be important as we move forward. The system, I think, before the virus was very much one, whether you were looking at the courts or police stations or prisons, you found a very patchy approach throughout the country without necessarily any consistency, with it being left to local areas, local courts, local prisons, police stations, basically to do what they wished. We've now seen a much more effective degree of, I won't use the word guidance, and some people don't think that's the right word, but at least thoughts coming from the centre about safety in the courts and the way in which cases should be listed. And I think, Kate, that's going to be a very welcome development for the future. And I hope the kind of welcome development we've also seen is some actual involvement at the beginning by barristers and solicitors who spend their time with the very people who the system is designed to help the public, rather than, I think, as it was in the past, was very much the professions would be presented with a solution which had been worked on elsewhere to say, here it is, are you okay with that? No, that should happen right at the beginning. Technology. We have a system which, for perfectly good reasons, relies very heavily on the oral tradition and the physical presence of judges, court staff, solicitors, barristers, victims, witnesses, them being physically present. But there has been clearly insufficient prioritization and insufficient use of the technology which already existed. It's not as if we woke up one day and discovered that there was such a thing as a video conferencing facility, or even greater use of the telephone. These always existed, and I endorse exactly what Amanda has said. I think we have a wonderful opportunity here to work out, where is it that machines can really add value? Why is it that case management hearings and hearings about procedure needed everybody to turn up at court? They don't. And if we can use technology in the right way and start freeing up the courts what they really should be used for, which is human beings experiencing justice from fellow human beings, then I think we're going to see, and I hope we'll see, a very significant change and improvement in the kind of reduction in the backlogs, which is so necessary. So in conclusion, what I would like to see is a data-driven analysis of the reasons why people come into the system of justice in the first place. Free early legal advice in those areas which are expressly designed to stop people coming to the system of justice, look after their problems. Proper and full investment in the professions in relation to the CLAR review, which is coming up and has been taking far too long to come to fruition. Proper investment so that there will be lawyers there in the future, and not God forbid, one day some kind of public defender service there, because the criminal defense community just no longer exists. And solutions, cases being dealt with by a combination of technology and the human being, so that ultimately the human being will be able to say that from beginning to end, somebody listened to me, somebody heard me out, and somebody gave me a fair judgment. And those are the kind of outcomes which we will need absolutely to see in the future if people can have confidence in the system. I'd like then just to conclude in relation to the important points being made earlier about the rule of law. And just as no doubt as to the position which we have set out, I said publicly and loudly, to hear this country proposing to breach an agreement just entered into, breaking international law, even in a specific and limited way, is shocking. And it's because of our commitment to the rule of law, that our system of justice is respected globally, that countries want to do trade deals with the UK, and that we can comment on state oppression in Belarus with credibility. And I hope very much that in the time ahead, that we see a significant change in what we've seen over the last few weeks. Thank you very much indeed.
Thank you, Simon. And there's one point I'd like to pick up on, and that is, as I think you know, I helped set up the IP pro bono service, and that was partly in response to the number of litigants in persons going through the IP Enterprise Court, and the recognition by the judges there that those litigants in persons were not getting the justice that they needed. But interestingly, 2 years on, we're now seeing that it's the early guidance that's actually more important. And so we're putting more resource into actually trying to educate people about intellectual property before they even get into a dispute. So I absolutely endorse a lot of what you've just said. So thank you for that.
And thanks for doing that.
I want to pick up on one of the questions that none of the panelists will have actually seen because it was submitted in advance, but I think it's a good one for you, David, and I know that you won't be able to stay for the entire time. So I just wanted to start with a question from Jonathan Smart, and that's about the erosion of rights with this populist government, flagrant contravention of international law as demonstrated in the Internal Markets Bill. And he's asking, how do we engage with people about the loss of freedoms coming down the line, and how with this juggernaut majority do we prevent this government having carte blanche simply to do what it wants? So I think that's quite interesting, him asking about engaging people on the ground.
Well, the question goes to the heart of the matter, and it's sort of strange to say to the Society of Labour Lawyers, but we have to park at the door the lawyers bit, frankly, and the legalese, and return to fundamentals, return to history, and to why and the sorts of people that fought for these, not necessarily rights, but these freedoms that we enjoy, and to mobilize, understanding in everything we do that there are two audiences. Of course, there's a narrow audience that we're, so we're looking at judicial review. There's a narrow audience which is about administrative law and legalese, but there is a public audience which is about the sorts of people, and you find this the most sympathetic people, frankly, who've relied on judicial review. Everyday things that people can understand. Any of us who've watched that fantastic 3-part documentary on Rupert Murdoch, many of us sort of detesting, frankly, the Murdoch empire for years, will have noted that the point at which the discussion turned was the Millie Dowling episode and going after Millie Dowling and her parents' phone. Suddenly, there was a case that commanded public understanding and empathy. And similarly, we've always got to be looking for those points and the very fundamentals of why this is important. So the truth is, in talking about human rights, it's hugely important to remind the public that Churchill was one of the people that gave us the current architecture of European human rights. And so, I think it's a return to basics, really, in our discourse and our language. But as I say, that the work that we want to do as a team to really understand how to describe and talk about these things is really important.
I don't know whether any of the other panelists want to come in on this. I think, Simon, you picked up on a few of these points about language and listening and communicating.
I think in terms of it's obviously difficult that on the one hand, when it was Article 50, a number of people quite rightly saying, hang on, Parliament must decide. So now we have government saying Parliament's going to decide, but it has a majority. I wouldn't myself in any way give up on the parliamentary process. Right now, the Law Society and the Bar Council jointly have briefings out there with MPs, and if David and Charlie have seen them, and asking, saying, please vote against these provisions. And I think it's fairly clear from what's been reported in the press that there are a significant number of MPs who were going to be against it. I've heard what Charlie said about the deal that's been done. But it's not over yet. So I would certainly say to anybody who has the kind of concerns about the way we're heading is to get onto your MP right now and say, if it's somebody who's otherwise going to be inclined to be voting in favour of these provisions, to be going to say, how on earth do you justify what you're about to do to your constituents? So I wouldn't give up on that.
Okay, can I just come back on one thing? Obviously, the government will continue to frame Parliament as an elite and other things, and it almost us against the public. And one of the things that's cutting through at the moment is actually framing discussion as one rule for Boris and Dominic Cummings and another rule for the rest of us. And it started really when Cummings broke the law and got away with it. And obviously, you know, Boris Johnson's been getting away with it for years. So it's hugely important when we talk about things like judicial review that we cite it as, these are the public, this is for the public, and these guys are getting away with it. And actually, even just in the last week, I think that the distaste with which, if you're at Eton, you can have a test, and great for the kids at Eton, but the public can't get one, and schools are shutting down and all the rest of it. Again, it's that sense of one rule for one group and another rule for the rest of us.
Just to add to what David has said, I agree with him that this can't, in a sense, in the long term, be one as a lawyer's debate. Ultimately, you've got to give a reason. And I mean, I wonder the extent to which, when we talk about breaking the terms of the withdrawal agreement and the Northern Ireland Protocol, whether or not most people's view about that is not determined by their view on the rule of law, but is determined about where they stood in the Brexit deal. So if you're a Remainer, then you're in favour of the rule of law. And if you're a Brexiteer, maybe you're not so concerned about it, which is very indicative of what David is saying, that there's got to be the fundamental issues as to why we've got it have to be debated. And I think finding the language and making clear to people why the rule of law matters is very important. Having said that, I think it is incredibly important to engage wider civic society in making sure whatever mechanisms currently exist to try to protect the rule of law are effective. And that's why I think it's incredibly important that the Law Society and the Bar Council should hold the Lord Chancellor and the two law officers to account. If they will not protect the rule of law, which is their job, then they should at least be paying a price in their own profession. I don't mean disciplinary proceedings, but their own profession, saying, we are depending on you and you're not doing anything about it.
In fact, we have had a couple of questions for the Law Society and the Bar Council saying, why can't they be disciplined? So Amanda, do you want to respond to those questions that have been coming up on the screen?
Yeah, well, I mean, as Simon's read out the statement that he has written, and anybody wanting to read the Bar Council statements, the statement that I've read, you just go on the Bar Council website. But the fundamental is that the law officers must defend the rule of law, and even when it's unpopular with government. as far as the actual job of the Bar Council, as you all know, we are separate from the disciplinary arm of the profession. It's the Bar Council's the representative body, and the Bar Standards Board is the disciplinary body. And I think it would be surprising if there hadn't been missives gone to the BSB. But for my part, I can tell you that it doesn't seem to me that it's the Bar Council's function to do that. Actually, you know, we represent 17,000 plus barristers, and Simon represents many more solicitors. And of course, it's right that all the law officers, as it happens, are barristers. None of them are solicitors. I think I'm right in saying. And so they would all be under the regulation of the Bar Standards Board rather than the SRA. But for my part, I really do hope that there's a change of heart in government and that it changes. And I understand what has been said about the bill, and I understand that, you know, that the amendment was agreed, and all it's done in our view is to kick the problem down the road. But frankly, it is still conceivable, as Simon says, that there will be a change of heart. And frankly, this is not a game of chicken. It's not a game of chicken either within the country or within the negotiations with the EU. It's the rule of law, and it should not be subjected to a sort of a game of who's going to hang out for the longest.
I'm sure we'll all agree with that. Just going to move on to a different topic that's come up in a couple of different questions. First of all, from Jane Kirkham, who's the Labour Group Deputy Leader on Cornwall Council, and also from, oh, now I lost the other question, about how can we make the law local again? And obviously from Cornwall, the specific question was, how can we improve access to justice in places like Cornwall, where there are these legal aid deserts and advice deserts? And I suppose the specific question looking forward to when we win power in 2024 as well, not just complaining about what the government does now. So I suppose that's Charlie and David to start off with.
Look,
David.
I think it's right to say that, you know, the access to justice issues and the advice deserts that exist are not just, sadly, about the underfunding of the Ministry of Justice. It's also about the chronic underfunding and the 50% cut in local authorities across the country. And it's the two combined that lead to this dire position, frankly. Now, obviously, we're committed to a devolution agenda in the Labour Party that is right about putting, you know, the local authorities back into the driving seat, devolving downwards, neighbourhoods, and with neighbourhoods comes proper advice. Clearly, we have to reprioritise access to that advice and legal aid. There's going to be a lot to do in 2024, and as a result of the recession, depression to come, it worries me hugely where advice might find itself, frankly, in the next few years. But I think it's that commitment both to local government as well as to justice that will see that come through. There are some other areas that I worry about. I worry about our magistrates and that element of local justice, the age profile of our magistrates. When I did my review, I was surprised and concerned, and this wasn't just about ethnicity. There seemed to be fewer and fewer working class magistrates, never mind the closing of magistrates' courts. And so there's an important component to do with localism that's sort of got lost in our justice system. And whilst we obviously focus on things like the rule of law, human rights and other things, it's important not to lose that local dimension. So I'm very grateful for the question, and to have any Labour colleague in Cornwall is a great thing. So I hope that there's an invitation to the front bench team to get down there, because I'd love to understand the issues as they are deep in the southwest.
Can I just add to that, Kate? Oh, sorry, if Charlie was going first, let me interrupt you, Charlie.
No, you go, Simon.
It was just to say, so was it Jane, the questioner?
Yes.
That's just going to sound a little bit corny, but Cornwall has a very dear place in my heart, because my gran and grandpa lived in Falmouth for many years, and I used to sort of spend a huge amount of time with them on Guinea Bays Beach, and then I proposed to my wife on the cliffs of Gunwallow. So Cornwall is, and it's also one of the first places I visit as Deputy Vice President. I think, Jane, what I would say, if you haven't done already, it's really worth linking up with your local law society. Well, I've spent a great deal of time down with the societies in the west of England, and as you know, well, certainly you will find they're well up to speed in relation to all the figures about the advice deserts there, and the average age of criminal duty solicitors. Cornwall's one of the key focuses there, so I would certainly get stuck in with the local law society, and with me as the individual president. You contact me, email me about any particular issue you want me to raise with the Minister of Justice, and I'm delighted to do so.
I was just going to say, I mean, Jane's question is very pertinent when she describes 500,000 people in Cornwall who don't have access to a housing solicitor. And I agree with what everybody has said about that. And I do think in considering what we would do about it as a party we got to government in 2024, yes, it's about resources, but it's also about ensuring minimum standards of access to justice. And that's why Willie Bark's proposal that there be an independent body that sets that, and it would not be satisfied wherever you put the requirement for access to justice if you couldn't find a housing lawyer in your own county, which is what Jane is saying is the position in Cornwall.
Could I just add something in relation to local justice? What's interesting, I think, as well, is that obviously there are areas of the country which simply don't have sufficient legal representatives to enable people to get legal advice, and therefore their rights are undermined. But what is going on at the same time is whenever we ask for a national reaction and protocol to the way that courts or tribunals are working on things, particularly actually in the county court and the Crown Court, we're told no, this is a matter for local judges and local areas, and so there's a very frustrating kind of binary attitude towards how to solve these problems, and I'm talking particularly about COVID, actually, to the problems that COVID-19 has thrown up, but or the state of justice that has thrown up as it is now. But it is interesting, because on the one hand there seems to be a commitment to local justice, and on the other it is demonstrably lacking.
Comes back to the money, doesn't it? And just for your benefit, Simon, apparently Jane is from Falmouth and her council seat is in Falmouth, so there's a good connection for her.
Great. Okay.
Moving on to a different topic, and this is an interesting one because it may divide our panelists, in that Charles Mallon has asked, now that we are pretty much used to remote hearings with considerably reduced costs for clients, why can we not have more in as many jurisdictions as possible? And maybe I initially misinterpreted this as thinking of jury trials, but that's not actually what the question's about. And it may be it's more referring to the CMCs that you were, I think, Amanda, you were referring to. So more hearings?
So I think that there's a very important role for technology, and I think you're right to say that it can save money, but I think it's incredibly important that it's only used for the right kinds of cases and the right kinds of hearing, and it is not used in a way that actually dissociates people and makes them feel as if they aren't getting justice at all. And it's deciding which hearings they are that give that, and which hearings actually take away from access to justice. So if I can give you an example, you may be very well familiar with them, and forgive me if you are, but it's been demonstrated that there are some sorts of cases which people feel that even though they're able to see people on a screen and they can see the judge looking at the papers and they can see their lawyers, actually what they actually end up with is that they don't have any real sense that they've got a just hearing. They aren't involved in it in the same way that you are if you're actually in the room. There is a feeling at the end that they haven't had first-rate justice. So I think there's a real worry that costs will drive down, will be driven down by remote hearings, but that will encourage ways of working that are not in the public interest. And that's a serious concern to me. Having said that, there are some new ways, relatively new ways of using technology, for example, online divorce petitions, those sorts of things, which have proved incredibly successful and which have allowed many people a much better experience of getting their divorce rolling, as it were, than it was before, because there are far fewer mistakes being made in the process. And for me, okay, that might cut out some lawyers. Well, I don't mind about that. What I mind about is that the people who have got the experience of justice are getting the best experience that they can. And so for me, it's really important to ensure that it's the right hearings that are remote, it's the right processes that are remote, and those that are basically the kind of things where you've got contested hearings or very, very serious outcomes. For example, people having their children taken away from them while they're on the phone in the room with the children. I mean, that is obviously completely unjust, the whole feeling of what is going on, because after all, court proceedings are formal and serious for a reason, that they affect people's lives, sometimes forever.
Can I just say something quickly, Kate, and then I've got to duck off, if I may, which is just to say, I mean, to endorse everything that Amanda said. Clearly, in a sense, COVID has accelerated the use of technology. In simple terms, you can see its use on the civil, commercial side, and things won't quite go back to what they were. But we've really got to be careful in those sensitive areas where we're involving vulnerable individuals and people for whom, for example, English is not their first language, or indeed there are issues about their educational background. And just also to say that I've been very concerned in this period. Another fundamental plank of our justice system is open justice. And open justice, our justice system has not been as open over this period. And that, there are key areas where what's going on has been quite hidden. In fact, I mean, even the pretense that courts are open and anyone can walk in is not actually the truth. I mean, security guards will turn you away to many of our courts if they turn up. Never mind technology not actually being online and available for people to see, or indeed journalists to see. So, things won't go back to where they were, and we should embrace the use of technology, challenge it where we're involved in vulnerable people, but understand that open justice has got to be a principle that we uphold. You'll forgive me that I'm going to leave you, but thank you so much.
Can I make a small point? Thank you, Dave. Can I just make a small point about the profession and the impact on the profession of remote justice? And again, it seems to me it's not about barristers per se, but it is a side effect of remote hearings, and that is that ordinarily when you're a barrister, you're hanging about waiting for your case to get on. So you hear other cases and you see how other people do their work, and that's part of the open justice that David was just talking about. And that is a way of learning. It's got two functions that are nothing to do with justice in the moment, but are very, very important in the long run. The first is that you experience and see good and bad examples of advocacy, and that is very important. The second is that you have solicitors or other people might see somebody in court they don't know at all and be impressed by them, or indeed the opposite, and make decisions about who they want to represent their clients in the future. So that kind of lack of open justice, which happens when you've got remote hearings just because they are, very siloed, it is an issue. And one thing that's a practical repercussion is it's very much more difficult to have those kind of side informal conversations that are necessary to move cases along, to settle things, to agreed facts or whatever it is that happens, to narrow the issues. It's much, much easier to do that face to face in real life than on a screen. So that's a repercussion for justice, which is a bit difficult to encapsulate and perhaps to evaluate its use, but it is tangible nonetheless.
And perhaps Kate, if I just chip in as the last bit, as you can hear, far from the questioner dividing us all, is actually managed to combine us, because I think to me something really important here, some words which we need to hear and use all the time: public confidence. The system must exist to serve the public. It's not the job of the public to somehow conform itself to the system. Technology is going to be hugely important for procedural hearings and the like, and will save a great deal of time and money. But we must remember that by and large, court is being used as last resort. People are regularly coming to court only when all else has failed. Leave aside perhaps some of the criminal work. From the civil side, they've tried everything. It hasn't worked. Now is the time they want to go and get justice. They want to have a hearing. To then be told, well, actually, you're going to have this hearing and you're going to join by your phone, and you're there struggling away with poor reception, etc. Is this person experiencing and feeling justice? Absolutely not. So we can be very careful that we don't find ourselves being led by data rather than us using data, and find ourselves being led by technology. We must make sure that whatever happens, that the public can still have confidence that if they have a problem, they're going to darn well be heard.
Kate, I do strongly agree with what Simon and Amanda have said. I really think one has got to underline the importance of this not being led by the lawyers. It's incredibly convenient for many lawyers to be able to conduct hearings remotely. For so many clients, it is a terrible injustice. And Amanda made the point about taking your children away on the telephone or in a hearing when it's all happening in front of the children. That is the most powerful example of, if Zoom hearings become more prevalent because they're so convenient for the lawyers, then the justice system will get yet more inaccessible for the very many people who need it most, because in addition to all of the other difficulties, there will be the digital divide that applies. So your ability to have access to the necessary equipment, but also your ability in the accommodation in which you are living to be a witness, to be a claimant, to give instructions to your own lawyer. Because remember, in order to work effectively, as Amanda rightly pointed out, you need to be able to give your own lawyer instructions while a hearing is going on, which will be very, very difficult. And statistics will suggest that certain sorts of hearing will be dealt with more quickly. And I worry that in the age of Corona, we won't go back on too many things. And one of the things that we won't go back on is interim hearings being dealt with remotely, when so many interim hearings, particularly in the family area, are ultimately decisive of what happens to parents and children.
We've had a few questions now on the issue of the Constitution. So both Jackie Stanford and old friend Katrina Monroe up in Scotland asking issues about whether we can see a commitment to a written constitution in Labour's next manifesto. And Katrina phrases it in the context of the EU having been an important protection against breaches of rights. And from now on, we're reliant wholly on weak protection in domestic law, which, as we know, can be flouted or eroded. So it's one for Charlie, I suppose, but views from Simon and Amanda also very welcome.
Well, I mean, obviously we haven't, as a party, got anywhere near a formulation of what our position is in relation to written constitution. I personally have been quite opposed to a written constitution in the past because I don't want the judges making decisions on policy. I want the politicians making decisions on policy. Equally, when you look at the states, you can see the extent to which there being a written constitution, with the last word being held by the judges, leads to the judges operating in what can only be described as a political way. But never in our lifetime has the government been willing to break all of the constitutional principles that previously, not all, many of the constitutional principles that previously governed our country. And breaking law is one. Another is the extent to which they have, with great ease, turned the civil service into a body that is just like a bunch of junior ministers. The permanent secretaries are fired at will as if they are junior ministers, and the civil service is fantastic. But if you do that to the leadership, you will soon find that agreeing in an unimpartial way is what's going to really matter. I mean, the final example is Baroness Harding, who is in charge of track and trace, and she's in charge of public health in the UK, in the England and Wales now. That is a very major civil service job. She's a backbench member of the House of Lords. She is whipped. Last week, she was voting along with the Tory whip for the agriculture bill. We don't have a civil service that is whipped to be political. And yet that's happening with hardly a bleep. The significance of a written constitution is you would need some process by which it was hard to change it. And that would provide protection, for example, for the political impartiality of the civil service, for probably the support for jury trial, and probably the rule of law. Because without some entrenched rights, they'll just be broken like they're being broken at the moment. So we need to have a discussion about a written constitution, and we need to make decisions about whether or not things have so fundamentally changed in the government's adherence to law and principle that there needs to be a change. Simon,
Amanda, any views on a written constitution?
No, it's not so much sort of policy, but because perhaps just more just some observations building on what's just been said by Charlie. It's maybe just because I've always been a great proponent of the phrase "be careful what you wish for," because whatever we put in place, we're going to find has got all kinds of entirely unexpected and unforeseen consequences. And once it's there, it's going to be incredibly hard to change it. What I would say about the present system, as to, of course, no system is perfect, but we have the fine example now of twice the Supreme Court holding government to account. So they've been able to do that without a Bill of Rights. So I like Charlie, I thought it through carefully enough. But the system as it presently exists, we've seen the rule of law upheld by the top court in the land, and I'm not sure that many countries around the world will actually be able to point to such a success, even in places where they do have bills of rights.
For my part, what really matters is that we do not derogate from the Human Rights Act. And of course, the question of whether we have a written constitution or not has pros and cons. But for me, I'm very, very concerned about any derogation of rights that affect the public. And that seems to me to be a path that we should be very anxious to avoid.
I mean, in a way, what Amanda says supports the written constitution, because one act of parliament, and that's the end of the Human Rights Act.
Well, let's hope it's not while you're there.
Absolutely. Well, let's hope we get back into power to make sure that doesn't happen. But just to move on to a slightly different topic, and it does have a great impact on the system of justice, but it relates to the so-called war on drugs, and just wondering what the panelists think about taking a public health approach to this issue, which would then, of course, take pressure off the justice system. And I can't find who asked that question, but if I can, I will mention it at the end. But there is obviously
Lee Birkwood. Lee
right.
Birkwood.
Thank you, Charlie. Yeah. Your eyesight's obviously better than mine. Yeah.
Well, I mean, I am on record as saying that the war on drugs is one of the most conspicuous failures of policy over the last 40 or 50 years. And what has happened over the last 40 or 50 years is that all the major developed nations in the world have handed over the illegal drug trade to criminals. And the consequence of that has been those who perhaps need a public health approach rather than a criminal law approach have been left on the outside rather than the inside, which has then led to much, much worse crime as a result. It is, I'd have thought, screamingly obvious that we need to look at this. Now, the Labour Party's got no position on this at the moment, and its position in the manifesto last time was that we should be moving towards a public health approach, and an effective move towards a public health approach means not just treat users as being people who are entitled to public health support. It also means, how do you deal with the illegality of drugs? Do you make it criminal to deal with them, which is the current position in every single respect, or do you make it much more a regulatory matter? I mean, if you look at alcohol in the United States of America, it was criminalized between the wars. It was then moved from criminalization to regulation. The effect of criminalization was that people increasingly thought up more and more potent concoctions that people drank. So, as it were, wine and beer didn't do that well, whereas more and more spirits with the highest degree of proof did. And then when you got rid of prohibition, you then ended up with a large collection of the criminal fraternity losing their fortune. And I think that's what we should be thinking about at the moment. We need to discuss it because it is such a failure, and it is a failure that has impacted to such an extent on every single part of our communities.
I'm not sure whether the Law Society or the Bar Council or Simon or Amanda personally have views on this.
Well, what I would say is, in my day job many years ago, I started off being a general criminal practitioner, and I can definitely say that over the period of about my first 10 or 15 years in practice, the landscape completely changed, and it was drugs that did it. It was the fact that it wasn't just people taking drugs, it was people burgling houses to get money to pay for drugs. County lines obviously now is a massive problem that has a people trafficking aspect to it. I mean, the Bar Council doesn't have a position on it, but I think it's a very difficult thing to have a black and white solution to it, because it has got such incredible reach all the way through the criminal justice system, and it is the backbone of so much offending.
Just as a final question, because I want to wrap up in a few minutes, and this there are two questions that have been submitted, not that you'll be able to see it by the panel, but they're about whether or not we actually do need to push now for a nationwide salary legal service following the Rushcliffe recommendations. And that was one question. And in fact, that links in with a question submitted by our own Fraser Whitehead, which was why treat legal aid as a problem rather than an answer?
Well, shall I deal with that second part? I mean, may link in with the first, for example, but really a question of substance. I think it's great in terms of here. It's been for a long time that there has been an attitude, I think, by governments of many hues, not just the present one, that legal aid is in some way some appalling gravy train for lawyers and should be circumscribed and got rid of as much as possible. And I think Charlie Falconer himself highlighted some years back, it looks like there were some problems a considerable amount of time ago. But I think that to the extent that any government, and including this present one, thinks that the public takes the view that legal aid is an absolute shocker, they're wrong. In terms of our own research, we had a huge piece of research done last year by YouGov, and it found that I think some 92% of people who were spoken to were in favour of legal aid. Law Society carried out its own survey about 18 months ago, which showed that actually the public did now regard the system of justice as important as NHS. And I think that we shouldn't take the public as in any way fools. The public are aware that if you didn't have legal aid, then you are going to have more and more people there seeking to cross-examine witnesses and victims themselves in some quite shocking circumstances. And they do understand that actually legal aid is a way to reduce burdens on the system and to avoid, let's just take a good example which maybe the public isn't hugely aware of, but as a matter of common sense, circumstances where you need, when you're considering, let's say, what your plea is going to be, you need to be advised by a lawyer who you trust and in whom you have confidence. It was a point made by David Lammy in his separate report. If you don't trust the person that you're going to be speaking to, or if somebody isn't available, then the chances of you pleading guilty and getting out of the system are seriously diminished. You don't have trust, you plead not guilty, and then as a result, some consequences which perhaps you didn't merit. So I think perhaps in a sort of in a rather rambling way, I would say that legal aid has been regarded very much as the problem rather than the solution, and I hope that view has changed, and the proof of that particular pudding will be what happens in Clark.
I'm not sure whether the question is limited to criminal cases, but of course there is a really big issue with people getting help where they need it in relation to lots of different areas of law. And what I think people don't think about is that if you have a state-run legal service, it's going to cost the state a huge amount of money because employees have rights that individual practitioners don't have. You have to pay them pensions and holiday money, and there are lots of hidden costs that the individual or practitioner is taking on themselves. So the overheads for having a service that's run by the government is actually really, really expensive. And actually, what we've asked for in our submission for the spending review is, first of all, early legal advice. We completely agree that it's necessary, and we that solicitors typically, it could be a direct access barrister, but typically it's solicitors should be there giving early legal aid, early legal advice to swerve people away from problems that will only be exacerbated if they don't have it. And secondly, it seems to me that what happens as things go on is that people aren't really aware of exactly what their legal problem might be, or it might be partly a health problem, partly a legal problem. And if you don't have somebody who's got experience across the board, as many high street solicitors do, at identifying what the issues really are, I think the system will, first of all, not work as well, will be more expensive, and public access to justice will suffer.
I agree with what Amanda and Simon have said. I'm very against a salaried legal service because ultimately it will be completely owned by the state and it will lack the independence of the current arrangements. And although one could see the CPS is independent in very, very many respects, if you are in a perpetual negotiation with the government about your terms and conditions, that is going to affect the genuineness of your independence, I think, in a large number of respects. So I think it is far, far better that it's dealt with by independent firms rather than people who are the employees of the government. Secondly, and separately, legal aid is for everybody the solution except for one entity, and that is any government. Because the effect of there being genuinely available lawyers to appear for the claimants in universal benefit who've been denied what they're entitled to, the asylum seeker who's been denied a fair hearing, the whole range of people who are entitled to what the state has given them as a matter of rights, is made all the more expensive and all the worse for the government by a properly functioning legal aid system. So no wonder they are always against it and always trying to limit it. There's a great exchange in the 1950s between the permanent secretary at the Home Department and the permanent secretary at the Lord Chancellor's Department, in which the conversation goes along the following lines: why do we need to give people who are defendants in criminal cases legal aid? Most of them are guilty, and therefore the percentages that will be affected by this are very, very small. And that is the attitude that the state always has. So legal aid is the answer, not the problem, except if you're the government.
Well, that sounds a bit like a final statement, Charlie, but I will give all of you a couple of minutes to just add any final comments, whilst I also thank you both, or all of you, very much for joining us, and also a big thank you to the Bar Council and to the Law Society for sponsoring tonight's session. So over to you, Simon.
Right, that's just to start. I mean, I stepped down as president of the Law Society after having been briefly extended in mid-October. And looking back, when I started, and every president comes up with their own presidential theme, I chose mine, Kate, you've got to do it obviously before you start being president, and I chose mine, upholding the rule of law. Little was I to know that actually I think that the rule of law has frankly captured the public imagination. I remember a little while ago, before lockdown, I was actually at the Supreme Court waiting to see Brenda Hale, and was just flicking through the newspapers, and outside her office, every single newspaper, well, 5 of them, but you know, they 5 different titles, had the words rule of law somewhere on the front page. And so I think in terms of the public, in terms of what they will expect to see from this government, indeed any government that follows, is support for the system, support for the professions, and support for access to justice. So funny enough, in the light of what has been happening during the last year and before, I think that the public in the future will demand that something's done.
Great. Amanda.
Just to say, I think that the 2 main headings for any lawyer, in my view, should be access to justice and the rule of law. And those 2 pillars need to run through the whole system. And if you take anything away from either of them, actually what you're doing is treating the public to a second-class service, and it's not one that they deserve.
Thank you. Final word, Charlie?
Yeah, just to say it's really big what's going on at the moment. Big because the government appears to be perfectly happy to be lawless, and that has very major consequences. Big because the ability of the citizen to access the courts, get legal advice, and exercise the rights they've got is getting worse and worse. And thirdly, it's becoming increasingly difficult to get that message across. I think Simon is right that many, many more people are engaged in justice issues. My worry is that the justice issues will be seen by people as it were, the last twitch of the Remainers, rather than the much, much more fundamental issue that it is. And it's only when more and more people are badly affected by it that it will get traction. That's why it's really important, I think, for us politicians to reach out and try and build coalitions with civic society, particularly the Law Society and the Bar Council, to ensure this is about not just the politicians, but much, much wider society. Because if we don't deal with the issue of the lawlessness of the government and people having access to justice, then everybody is going to be affected in their pockets and in their freedoms.
Well, I think what we've seen tonight is that there's a lot that we all agree with, and that there is a lot of work to be done for lawyers in supporting access to justice and the rule of law. So I think continuing partnerships between all of our organisations is the way forward. And just a word to those people who are attending this evening who are not members of the Society of Labour Lawyers. If you are interested, do please get in touch. You do need to be a member of the Labour Party first, though. So just before we finish, I'd just like to remind people about our two other Fringe events this week. We have 8:30 tomorrow morning on Brexit, COVID and financial services. And then on Tuesday morning, COVID-19 and the justice system. And that follows up on the report that we published earlier this year with a lot of our members from the junior labour lawyers contributing, and also talking about what it's like at the coalface for them. So a big thank you to all of our panelists again, including Ellie and David, who couldn't stay with us till the end. Thank you to all the people who've attended and for all of the questions. I'm sorry we couldn't get to everything. And then I just hope that next year we'll all be able to see each other in person. So until then, good night.